WCLN 1170 Radio and Star Vision Cable Channel 16 are pleased to present We Should Know, hosted by J.W. Simmons, an upbeat, informative look at people, places, and issues facing our community. This education-based analysis of issues will remain positive and informative as we consider closely what we should know.
Ladies and gentlemen, welcome back. I want to thank Nicole for her introduction she does for us each week. The name of the program is We Should Know. If you happen to be driving down the road and you're listening to us on WCLN 1170 Radio, also Star Vision TV. And as you know, you can see us on Star Vision TV Tuesday, Wednesday, Thursday, 7 p.m. We'll reprint the Sampson Weekly newspaper uploaded to YouTube on Wednesday of each week. You can pick up not only today's show, but other shows that we've uploaded. Just type in We Should Know EDU. And we want to thank you for all the comments that you continue to give us on last week's show. We appreciate those. We Should Know EDU at gmail.com. That's We Should Know EDU at gmail.com. Also, thank you for the suggestions you give us for shows about topics and subjects that really interest you and that's impacting your life. I want to start the show today and give a shout out to a couple of folks that's fixing to take a big step in their life. Jennifer and Jeremy Thompson going to Ecuador to do a little mission work over there. I want to give them a shout out and kudos for that and continue to do wonderful things. So today, subject that's I guess been on the news media quite frequently here lately. A lot of interest, a lot of emotion built around it. It's about gun control. I want to approach it in a little different perspective today and talk about the legality and the legal issues surrounding gun control. And we found a guy that should know a lot about that. He's got a background for it. And Jeff is with us, Jeff Welty. And Jeff is assistant professor of public law in government, Institute of Government, North Carolina State, University of North Carolina, Chapel Hill. His areas of interest is criminal law, procedure, evidence, prosecutor training, police attorneys, and his profile includes the School of Government in 2008. Prior to that, he completed a federal judicial clerkship. He spent 8 years in private practice and served as a lecturing fellow at Duke Law School. Welty holds a bachelor's degree from the University of California at Berkeley and a master's in economics and a Juris Doctorate with highest honors from Duke University. Jeff, I want to thank you for being here. And I had some of my friends wanting me to make sure that since you were from Chapel Hill that I mentioned the Wolf Pack. So I just thought I would throw that out. And
I think I heard something about a basketball game.
Yeah, you heard something about a basketball game.
That does ring a bell.
It does ring a bell. So starting off on a note here of information and education, this whole gun control issue has to start somewhere. And we've heard the Second Amendment over and over again. Let's talk about the Second Amendment and particularly what that says and go from there as we look at the legal issue.
Sure.
The Second Amendment, I'll let you take that on, but it starts out as a well-regulated militia. And it talks about being necessary to be and to have this sense of security in a free state. And as it goes forward, the right of the people, and I think this is the phrase that really in that Second Amendment, the right of the people to keep and bear arms. And it shall not be infringed upon. And that particular part of it, I have folks that will say, well, you need to read that part. So how does that unfold when we look at where we are now in this huge debate as it zeroes in on assault rifles, as it zeroes in on what has been termed as weapons of mass destruction?
Sure. Well, you're right. You need to read the whole thing in order to understand it. And the Supreme Court of the United States recently settled what had been a long-running debate. The Second Amendment starts off with a reference to the well-regulated militia being necessary to the security of a free state. And for a long time, there was one way of thinking, which was that the Second Amendment only protected the right to bear arms in connection with militia service or something like National Guard service as we would envision it today. And it didn't protect everyone's right to have weapons in their homes apart from that militia context. The Supreme Court in 2008 in a case called Heller versus District of Columbia rejected that line of thinking and said that yes, the concept of a militia is important historically, and it animates why we have the Second Amendment, but it doesn't, the right to keep and bear arms is not limited to that context, and every citizen, with some limitations, is entitled to keep and bear arms for lawful purposes like self-protection, hunting, and so on. So the Supreme Court really resolved one of the critical debates about the Second Amendment, which was, is it limited to the militia context, or does it apply to everyone irrespective of militia service? And the court decided that it's the latter.
Okay, and I think it's important to note that, because we're dealing with an issue that's highly emotional, and when we look at that, so we have a foundation that folks can legally, and by the interpretation of the Supreme Court, can own and possess firearms. Now, as we narrow that scope and think about all the things that fall into that category, we find ourselves in a situation when we're looking at certain areas, colloquial areas of the government, to include not only government but the United States and the people that exist in the United States, that there are certain people that see this as an inalienable kind of a birthright, not necessarily a law. This is something that comes with living in a rural area, living in an area of hunting, fishing, that kind of thing. What we're looking at now is more a sense of what is the type of weaponry. And of course, as you know, one of the people that is planning to introduce a bill is Senator Dianne Feinstein, and that bill talks about weapons and weaponry. Is there already existing laws in place that restrict certain kinds of firearms?
There are, and both at the federal level and in North Carolina at the state level, there are prohibitions on certain types of guns, and two common examples would be fully automatic machine guns in general are not available to individual citizens to possess, and then sawed-off shotguns and other short-barreled weapons likewise are not permitted to possess. And there's no question that that type of restriction is legal and constitutional and within government's authority. In fact, in the same case that the Supreme Court guaranteed the individual right to bear arms, they explicitly said, look, we're not calling into question the ability of the government to prohibit unusual and dangerous weapons like machine guns and short-barreled shotguns. So there are already some restrictions on what type of weapons you can have. The question that you're raising, I think, goes to, well, what types of weapons are protected and what types of weapons fall outside the Second Amendment scope?
Absolutely. So when we look at those weapons that fall outside of that Second Amendment scope, is there a certain amount of laws and the enforcement of those laws that are in place that prosecutors can now prosecute on, and has law enforcement, in your opinion, been, I guess, at the most aggressive point, being able to deal with that under the existing laws? Are the laws structured in such a way that a law enforcement officer out there enforcing the law can readily put into account and make those laws impacting, and can prosecutors prosecute those laws effectively, or is there certain additional meat that needs to be added to the laws?
Well, for the most part, I think the existing laws are clear. In other words, I think an officer who encounters somebody on the street with a weapon is going to be able to determine whether it's a prohibited short-barreled gun or whether it's a fully automatic weapon or something like that. So the clarity of existing laws is a plus. The policy question that folks are interested in right now is, do existing laws go far enough, and specifically, do we need something like an assault weapons ban, which we had in this country on a federal level from 1994 to 2004? Is that a good idea as a policy matter? Is it constitutional as a legal matter? Those are the unsettled questions, and we can talk more about either of those if you like, but that's the question. Is that an important tool that we need to add to law enforcement's arsenal, or does that infringe too much on the individual liberty of folks to have weapons for personal use?
You know, Jeff, let's talk about that whole issue of infringement and what is rightfully ours to have and to bear, and what the constructs are that law enforcement people and folks that are in the world of government that look at folks and say, well, we need to look closer into your home, into your bedroom, into your vehicle, into your trunk. There's extreme limitations on what law enforcement officers can and can't do already on the books. So the question then is, if Uncle Fred or Joe or whomever is driving down the road, that person's name is not important at this time, but they have a firearm in their vehicle, are we looking more at being more infringing on their rights, or is there enough there already to grant them permission to look if there's a law been violated?
Well, there's a whole separate set of questions surrounding what kind of tools law enforcement has to enforce the law, what type of search and seizure authority they have, and that kind of thing. That's separate a little bit from the gun control debate. But there's no question that law enforcement, when they come across somebody who's carrying around a firearm that looks like it may be a prohibited firearm, like a short-barreled shotgun, or somebody who's carrying a firearm in a way that may be menacing, has the right to stop somebody and investigate what's going on, detain them briefly for the purposes of investigation. And I do think one of the things that folks are concerned about is the more gun laws there are, the broader the authority it gives to law enforcement to stop and investigate people for potential violations of those laws. So there is an expansion of governmental authority and power and responsibility whenever you create new prohibited conduct.
Do you get a sense that in just your communications and the circles that you connect with, and obviously do quite a few of those circles, that folks are a little bit concerned about government involvement in their day-to-day lives?
Well, I do think people are concerned about that. You know, one of the fundamental things in this gun control conversation that I think is interesting is what a cultural divide there is. And you talk to folks on one side who are gun owners and who appreciate shooting sports, and everyone that they know has a gun and is involved in those same type of activities. And on the other side, you meet people who don't own a gun, don't know anyone who owns a gun, have never fired a gun, and really don't understand what the concern is. And it's very hard to get those two groups of people to talk to each other or to understand each other's concerns. But you're right that for folks who are gun enthusiasts or gun owners, there is a concern about a slippery slope, and that something like a ban on assault weapons or large capacity magazines could gradually expand and then become a restriction on handguns and become some type of further restriction. And there's a worry that once you take that first step, that other steps may become possible. I think that's a little bit of an overstated worry, because the Supreme Court's drawn a line in the sand saying that handgun ownership, for example, is protected by the Second Amendment, and so I think there's a limited risk of that type of slippery slope.
Jeff, we're going to take our first break. We'll be back in a moment. We're talking with Jeff Welty. Jeff is with the University of North Carolina. He's an assistant professor there. And we're talking about gun control from the legal perspective, what you need to know. Call a friend, have them to tune in. Ladies and gentlemen, welcome back. The name of the show is We Should Know. If you're listening to the program today, you might want to go ahead and call a friend. We're talking about gun control. We're talking about gun control from the legal point of view and the legal perspective. And we have Jeff Welty with us. Jeff is an assistant professor of public law and government at the University of North Carolina, Chapel Hill. He has some specialty interest in criminal law, procedure, evidence, prosecutor training, training for police attorneys. Jeff has just an excellent track record and profile here. He's been a federal judicial clerk. He spent 8 years in private practice. He served as a lecturing fellow at Duke Law School. He graduated from University of California at Berkeley as a master's in economics, and he got his law degree from Duke University with honors, and he's also been the executive director of the Duke Law Journal. Jeff, quite a background, quite a track record for a guy no older than you are. So I look at you, you've done a lot of things, seen a lot of stuff, and with just some of the things I read there on your profile, it tells me that you're eminently qualified to talk about gun control and gun control laws and legalities. We started this show talking about the Second Amendment. In the first segment, we've opened a door to a lot of issues and discussing gun control and what that may or may not mean. There are folks out there that, as we discuss this, that are probably thinking, well, let's talk about some of the very fundamental issues. Let's ask this guy, is it okay if my neighbor Fred or whomever it may be is told me he's going to buy him a new, so let's use pistol because we know pistols are a little more regulated. He's going to buy him a new pistol, and he said he would sell me his whatever, let's say 9mm Glock. He's going to sell that to me, and it's a real good deal, and I can buy it. Have I violated any laws by buying that?
Right. Well, good question. As a matter of federal law, the answer is no. You can buy a gun from anybody that wants to sell it for the most part, and there's no, when in a private sale like that, a sale by somebody who isn't a licensed firearms dealer, there's no requirement that you go through a background check, for example, or that a background check be completed before the sale. As a matter of state law, you may need to acquire a handgun purchase permit or something of that nature from your local sheriff, but there's very few, very limited regulations that apply to private sales of firearms like that, in contrast to the much more extensive regulation that applies to sales of guns by federal firearms licensees.
So this is where then we can get into discussion at gun shows, and I think one of the big debates that's going on now, and one of the issues that those that are looking at this issue of gun control wants to close is the loophole within gun shows in which you and I meet outside the particular location of the gun show, and you're not a dealer and I'm not a dealer, and you decide to sell me that gun, then that's perfectly legal.
It is. And let me start off talking about this by saying that I think the term gun show loophole is a little bit of a misnomer, because really the issue doesn't have anything to do with gun shows. If a federally licensed firearms dealer goes to a gun show, which they often do, and they choose to sell a gun at the gun show, they've got to do the background check and everything else that's required if they sell a gun out of their shop. The fact that they're at a gun show doesn't change anything for them. On the other hand, if a private individual who's not in the business generally of buying and selling firearms chooses to make a sale, whether it's at a gun show or outside of a gun show, they don't need to go through the background check process. So it's really not a gun show loophole. What it is an exemption for private sales. But you're exactly correct that private sellers don't have to go through the background check process and some of the other regulations that apply to federal firearms licensed dealers when they're selling guns.
And Jeff, you know, this is such a huge emotional issue, and it's emotionally charged, I think, for two particular reasons. One of those that we alluded to early on, which is this sense of a birthright that folks have, but even more so with the horrific kind of violence we saw at Sandy Hook and Newtown. And you know, we've had 2 or 3 shows on that in which we talked about the mental health issues and various other issues related to that. Even we had the superintendents of schools on to talk about security. But when we look at that emotional issue is driven from 2 different planes. One, the folks that rightfully say, well, we need to do something to assure that this kind of thing doesn't happen anymore. And by saying that, my question would be, are there legal things that we could do? Are any of the legal issues we're talking about now, or that Senator Feinstein is talking about in her proposal, of which what we know about now, addressing assault weapons, would any of those restrictions have prohibited what we know occurred at Sandy Hook? Okay,
good question. And let me separate for now the question of whether these restrictions would be lawful or not, and we'll just talk about whether they would have worked to prevent, for example, the Sandy Hook tragedy. The gun that was used, the principal weapon that was used by the Sandy Hook shooter was a Bushmaster AR-15 style semi-automatic rifle, what some folks would call an assault weapon. Connecticut has an assault weapons ban very similar to the federal ban that existed from 1994 to 2004, and it prohibits generally the sale of semi-automatic rifles that accept a detachable clip and that have at least 2 quote-unquote military features, such as a pistol grip, a threaded barrel, and other types of features. The specific weapon that was used was lawful under Connecticut's ban and would have been lawful under the federal ban because the only feature that it had was a pistol grip. It didn't have a second feature. And so one of the things about assault weapons bans is that it has been historically pretty easy for manufacturers to create weapons that don't run afoul of the ban just by limiting the number of specified features that they attach to the weapon. The overall functionality of the weapon is the same, the look and feel's the same, but they can tailor the manufacturing process to avoid the ban. Senator Feinstein has recently proposed a much more extensive assault weapons ban or weapons regulation that would be a 1-feature test. So a semi-automatic rifle that could take a detachable clip and that had even 1 feature, such as a pistol grip, would be illegal to sell under the Feinstein proposal. That proposal is not likely to pass, but if it did pass, it would have prevented the lawful sale, at least, of the specific gun that was used at Sandy Hook. Now, there's still a large number of guns out there that would be grandfathered under the ban, so whether there'd be any immediate effect is pretty questionable, but at least it would have been more extensive than the Connecticut law that currently exists.
So in looking at that and then discussing that question, and I guess the part two of that question, the finality of it is that everything was legally done at Sandy Hook as far as the weapons and their location of the weapons. The altering point at Sandy Hook was obviously, and I think in a number of these shootings, was obviously and apparently individuals that had possession of handguns that should not have had possession of handguns because of their mental instability.
Well, the connection between mental health and misuse of guns is something that's gotten a lot of attention after Sandy Hook and really got a lot of attention after the 2007 Virginia Tech shootings. And federal law already prohibits anybody who's been adjudged mentally incompetent or quote-unquote mentally defective from possessing a firearm. The question always has been, number one, are there people with serious mental health problems who've never been adjudicated as having them? And the answer to that is obviously yes, a huge number of people. And then number two, even for folks who've been adjudicated to have mental health problems, for example, who've been involuntarily committed as a result of their mental health problems, do we have an effective way to make sure that guns don't get into those people's hands? And the way that we have is the National Instant Background Check System, the NICS system administered by the FBI. And a serious problem with that system has been that contribution of mental health records by the states to that system is entirely voluntary. And about 20 states essentially don't contribute to it, either because they don't have computerized records, they don't have centralized records, they're concerned about confidentiality of mental health records, or for other reasons. So you have a system that has a growing number of records, but still is missing a large number of mental health records. So it's imperfect even for folks who've had contact with the court system as a result of their mental health problems.
And even if that system were perfect and not imperfect, if it were perfect, and that system were in place, given the dynamics of what occurred at Sandy Hook, as what's revealed in record, the purchase of those weapons would have been legally purchased.
That's right. I mean, in that case,
so again, it would not have changed anything.
That's right. I think the purchaser in that case, if I have the facts right, was the mother of the shooter, who didn't have any mental health history. The shooter obtained the weapon from her. So there's nothing that a better national instant criminal check system would have done to solve that. And I guess that's another one of the major points that I like to make when talking about the issue of gun control, which is there's no panacea here. Mm-hmm. I mean, anything that we can do, whether it's improved mental health tracking, if you think that an assault weapons ban is desirable and could be passed, whatever strategy you want to take, we're not likely to move the needle very much. Any one of these approaches is likely to make an incremental change at the most to the pretty deep, intractable, and multiply caused problem of gun violence.
And as we look back at that Second Amendment, we look at what the Supreme Court has done in defining and redefining that Second Amendment. You don't see any change from the Supreme Court or any cases moving toward the Supreme Court that would have any kind of change in what that definition of ownership of a gun would be?
No, I don't think so. I think the Supreme Court, having just decided the landmark case in 2008 and then followed it up with another case in 2010, has established a pretty solid precedent for protecting Second Amendment rights. We've talked several times about assault weapons, and the Supreme Court hasn't considered the constitutionality of an assault weapons ban, but a number of lower courts have considered the constitutionality of assault weapons bans in light of the Supreme Court's rulings. So far, all those cases have upheld assault weapons bans as constitutional, but none of those assault weapons bans have been as far-reaching as what Senator Feinstein has proposed. This one-feature test is a very stringent definition for assault weapons, and it may be that if that ban ever were enacted into law and were challenged under the Second Amendment, that the courts would rule differently on that than they've ruled so far with respect to other assault weapons bans.
And when we talk about one-feature test, we're really talking about more specificity in defining what an assault weapon is versus the generality that it may be an AR-15 or it may be some other kind of .223 caliber weapon.
Right. So typically the assault weapons ban have said if it's a semi-automatic weapon with 2 or more military features, that can be prohibited. And Feinstein's ban would be broader because it would go to that one-feature test. If it's got a pistol grip, it's an assault weapon, so it's very encompassing.
Jeff, we're going to take our next break, and we'll be back in a moment. Ladies and gentlemen, we're talking with Jeff Welty, assistant professor at the University of North Carolina, Chapel Hill, about gun control. Call a friend and neighbor and tune in. We'll be back in a moment. Ladies and gentlemen, welcome back. We Should Know is the name of the program. We're talking with Jeff Welty. Jeff is assistant professor, public law and government there at the University of North Carolina, Chapel Hill. Very eminently qualified to talk about legal issues as it relates to gun control. He has a degree from University of California at Berkeley, a master's in economics, and his law degree from Duke University, where he graduated with highest honors, and he was the executive editor of the Duke Law Journal. Jeff, thank you for taking time to come down to southeastern North Carolina and talk to some of the folks in the area here and wherever else this program may be picked up. We had a little fun with Chapel Hill State and the rivalry that goes on there with basketball as we came on with the show starting today. And I want to use that as kind of a catalyst to talk about this sense of rivalry that has been generated as a result of the horrific event at Sandy Hook, the rivalry, if you would use that term, to talk about the folks that see an inherent birthright to own guns and have whatever kind of gun they want to own, and see this as an invasion of their personal rights when we hear a law going into place. Because most folks, when they hear law, it's the government is acting on me again. And you've talked about federal law. What I want to do now is let's discuss that issue of how a federal law may or may not impact a state, and can a state conversely have a law that says, look, we believe we have, for example, the castle law, where folks can have a weapon on them, and if you invade my car or you're attacking me in some way, trying to steal my money or whatever, I can legally shoot you. We faced that in Florida, recently, and that case is still, I'm sure, engendered in your mind and what impact that may have. Well, let's talk about that now. Can the federal government, under the current administration, pass a law and that law impact us, even if our governor and our legislature says, no, we don't believe in that in North Carolina?
Generally, the answer is yes. Under the Supremacy Clause of the United States Constitution, federal law is supreme, and if the federal government creates a law, it's binding on all the citizens of the United States in all 50 states, regardless of what their state wants to do. So, for example, in the context of gun control, several states recently, I think Alaska's among them, and Oklahoma, I believe, are considering legislation that would make it a state crime for a federal law enforcement officer to enforce the federal gun laws in that state. Well, they can pass that law if they want, but that's an unconstitutional law that the courts will strike down, because the Supremacy Clause provides that federal law, as long as it's constitutional, reigns supreme.
So the example then would be, if there is a law put into place that background checks, national background checks will be imposed on everyone that purchases a firearm, then the states would not have any way to rebuff that.
That's right. Assuming that such a law would pass any kind of constitutional challenge that might be made to it in the courts, that law would be the law of the land, and it would apply in all 50 states, and no state could exempt itself by saying, well, we don't want to be governed by that. If it's valid federal law, it applies to you.
Well, let's reverse that thought process. And for example, in New York, we know that there's some laws that's been very aggressively passed there, and just it was like overnight. They voted unanimously to put into place some gun control laws. If that's contrary to federal, then can a citizen there say, wait a minute, this is different than what the federal law allows me to do? It's much more strict. Does the reverse apply?
No, the reverse doesn't apply. So a state can regulate more than the federal government does, but it can't dip below the federal level. So the federal level of regulation essentially provides a floor but not a ceiling, as they say in the law. And if your state law is more restrictive than federal law, you've got to comply with both at the risk of being prosecuted either by the feds or by state authorities.
Where are we at in North Carolina when we look at the state law in North Carolina as it relates, and I refer to it as the castle law. I don't think that's the exact title of the statute, but it does, and it did prior to Sandy Hook, and still does, because there's nothing been done to change that. It gave a broader gravity to a person to not only have in his possession or her possession a weapon, but also gave them a little broader scope of utilization of that, or at least a better comfort zone if they had to use that weapon. Talk about that for a minute and what you see this whole issue of gun control, what kind of impact it may or may not have on that.
Well, probably very little. The Castle Doctrine bill, which the General Assembly recently passed, is really about the law of self-defense, not about the law of guns. So it's about your right to use deadly force, whether it's with a gun or a knife or anything else, to defend yourself and your home from a violent assault. And I think for the most part, that bill codified something that was pretty close to what was already the law in North Carolina, which is if somebody attacks you with deadly force, breaks into your house, threatening you with deadly force, that you could defend yourself without having to retreat out of your own home in an effort to escape that confrontation. So I think mostly that bill codified what already had been the law, and I don't think that any gun control legislation that's at all likely to pass would have any effect on citizens' rights to defend themselves in their homes.
As we talk about these laws, I want to kind of clarify a bit for folks too. We're looking at a law that's passed, which is a state law, it's a federal ordinance, local ordinance, or a federal law. It's then used to be acted on by law enforcement people to determine if there is a violation of that law. But ultimately, the decision to prosecute falls with, as I read in your interest areas that you talk to a lot of prosecutors in the state, it's determined as to whether that's going to be prosecuted by the local district attorneys or the judicial districts. How aggressive do you see prosecutors in North Carolina in prosecuting some of these fringe kinds of cases as it relates to gun control? Is it something they really want to clog their courtroom with, or do they see it as something that, maybe I don't want to move on that, because ultimately it's up to them as to whether they prosecute it or not?
Well, it varies. Prosecutors are different from one another, and prosecutors are elected officials in North Carolina who are responsive to their constituents. So what a prosecutor in one area of the state might view as harmless, a prosecutor in another area of the state might think is more troubling. But I'll give you a common example, which is, in general, North Carolina law prohibits possessing firearms on school grounds. And every once in a while, you'll have a case where grandpa, who doesn't normally pick the kid up from school, goes to pick the kid up because, mom's stuck at work, and grandpa's got a gun rack in the back of his truck, and he brings a gun into the parking lot, not knowing or thinking anything of it. In many areas of the state, that's a case that if it came to law enforcement's attention, they wouldn't bat an eye at it, and they'd say, hey, Grandpa, don't do that again, and let him go on his way. In other areas of the state, law enforcement might take that much more seriously, and you might even see a prosecution arise out of it. So it varies, but in general, I think prosecutors try to use their prosecutorial discretion to focus on the most important cases and try to let slide folks who are inadvertently violating the law in a way that's not really threatening.
When we look at these cases and we think about the related issues to guns, we think about ammunition, various other things as well. And we talked about the requirement that may be a state or a local requirement that a person get a permit from a local sheriff before they can purchase a gun, even if it's a private sale. How about ammunition? How does that fit? There's folks, when we talk about these assault rifles, typically we're looking at, for those folks that may not know, a .223 caliber bullet, which is a bullet that is kind of designed for pretty much assault rifles in general when we use that term assault rifle, particularly the AR-15. How does that relate to ammo? Because again, one of the parts of the bill that we're talking about here that's being introduced addresses ammunition and clips.
Right.
A clip meaning the container that holds the ammunition that feeds into the gun. Is ammunition, the purchase of ammunition, an issue? Will that fall under any of these proposed laws?
Not that I'm aware of. For the most part, ammunition can be sold to anyone who's an adult. No background check is required. It can be sold sort of like tobacco or alcohol. As long as you can demonstrate that you're an adult, it can be sold to you without a lot of strings being attached. The capacity of magazines is a significant issue, and as you know, one of the provisions of Senator Feinstein's bill would be to limit the capacity of magazines to 10 rounds. Currently, it's very common that folks with semi-automatic rifles would have 15, 20, 30-round clips that can hold larger capacities of ammunition, and that's something that would be regulated under Senator Feinstein's bill and probably other legislative proposals that Congress may consider.
one of the things that is contrary to this, it's also a legal issue as well, is, again, back to the Castle Doctrine. There's a number, especially, we've recognized this in this area of the state, and I'm assuming even Raleigh has recently had some news media coverage on some things they call home invasions, in which folks literally burst into a home and invade the privacy of the home, and some cases do some pretty tremendous things there, and it's definitely illegal. Those people that say, look, I need my weapons in my home to protect me, how does that control of the amount of ammunition in the clip affect the decision process? And as we talk about this, some of this is subjective in nature. I mean, a lot of the law you can look at and say this is very objective, this is exactly what it says. But some of it's subjective in the sense that, I sense that what I'm hearing from a lot of the political structure, that we're not going to see a huge change in some of the gun control issues because there's favor on that.
Right. Well, stepping back just a minute for the big picture, I think you're right that there's some gray areas here, and assault weapons bans and large capacity magazine bans are probably some of those that are in a little bit of a legal gray area. The Second Amendment right does protect the individual's ability to own firearms and ammunition, but like other constitutional rights, it's not unlimited. I've got a First Amendment right to free speech, but I can't yell fire in a crowded theater. I can't slander anyone. I can't give national security secrets to our enemies. So there's limits to every constitutional right, and likewise there are limits that can be imposed on our Second Amendment right to bear arms. With respect to high-capacity magazines in particular, the governor of Texas recently was quoted in the news media as saying, if somebody breaks into my house to do harm to me and my family, I want to have as many bullets as I can have. I don't want to be limited to 3 or 5 or 10 bullets to protect my family.
Absolutely. And
I absolutely can understand that. At the same time, the larger the capacity of the magazine gets, the fewer the lawful traditional purposes that it serves, and the more likely it is to be used for nefarious purposes or mass violence. So there is a justified divergence of opinion.
Jeff, we'll take another break. We'll be back in a moment. We're talking with Jeff Welty, Institute of Government, School of Law there at Chapel Hill. Welcome back, ladies and gentlemen. This is kind of our last segment here, as We Should Know. We're talking about gun control. We're talking to Jeff Welty. Jeff is with the University of North Carolina at Chapel Hill. He's assistant professor of public law and government there. He concentrates in certain areas of interest that he has, which is criminal law and procedure, evidence, prosecutor training, police attorneys. Jeff has an excellent background, graduate of the University of California at Berkeley, a master's in economics. He got his law degree with highest honors from Duke University, where he was executive editor of the Duke Law Journal. Interesting background, and again, with gun control, there's all of these issues, and I guess some of our listeners may be, and oftentimes I'll get calls or questions when they know we have somebody like you on that has a track record of answering finitely what the law says about what we should or shouldn't do. And so I'm sure after we get through with this show, I'll probably get additional emails and calls, and folks will say, well, you should have asked him this or you should have asked him that. Jeff, is there a way if a citizen wants to connect with you that they could either call you, or I know you have a blog that very interesting, by the way, and I appreciate you doing that because you basically clarify a lot of things. And I would ask you to do this is not only just for the listening audience, but for law enforcement people as well. Your background is a definite asset for a person to either go online and look at your blogs. Tell us how we can reach you there, either by traditional telephone or via the internet, and look at some of the blogs you have on the internet.
Sure. The main blog that I write for is the North Carolina Criminal Law blog, and if you type that into Google, it should be your first result. It covers criminal law generally, not just issues related to firearms, but there is a fair amount of gun-related discussion there. And if folks have specific questions for me, both my email and my phone number can be found on the School of Government website. That's the UNC School of Government, which they can easily find. And my main job is to respond to inquiries from officers and prosecutors and judges and state employees who work in the justice system. But when citizens have questions and they call or email, if I'm able to respond, I'm happy to do that.
Okay. Well, I appreciate you giving us that information, and hopefully our audience will be able to follow up on some specifics that maybe I missed asking. Let's transition now, if you will. One of the things that President Obama decided to do was to act aggressively in I think paraphrasing some of his words, as a result of the Sandy Hook shooting, and Vice President Biden headed up a group of people that pulled together some, I guess supposedly 23 executive orders, which came down from the president as to how he and his administration would suggest addressing gun violence, which is, again, as we have discussed, to some people is not really the main issue we should be focused on. In fact, we've had a number of debates just recently on some of the Sunday morning shows. You could see the divisiveness and the line drawn between the folks that don't want any additional gun control and the folks that think that there's some part of that should be done. And it's become a media kind of event, and I want folks to understand that when we're doing this show, and we're trying to look at it a little bit deeper. So the question would be, what can or can't a president do through executive order related to gun control for the average person out here as it relates to what he can purchase, what he can't purchase, how he's regulated or not regulated, before it has to be brought before the legislative branch of government?
The short answer is not very much. Presidents have the authority as the head of the executive branch to issue executive orders, and for the most part that means they can order the military to do something under their authority as commander-in-chief, and they can order members of the federal executive branch to do something under their role as the head of that executive branch. So, for example, the president can order the attorney general to vigorously enforce existing gun laws, or the president can appoint an executive study commission to look at an issue further. All those things are perfectly common and traditional, and some of President Obama's proposed executive actions fall within that bailiwick. The United States Supreme Court has ruled, though, that what a president can't do by executive order is intrude into the legislative policy-making arena, and the key court case is a case about President Truman's attempt to nationalize steel mills in 1952 during the Korean War. They said he couldn't do that by executive order. Specifically as it relates to gun control, things like extending the list of persons who are prohibited from possessing guns under federal law, things like banning assault weapons or large capacity magazines, all of those would have to be done through an act of Congress. The president couldn't do those by executive order and hasn't tried to. If you look at the list of executive orders or proposed executive actions, you can see that most of them are in the nature of directing the CDC to research the issue, directing the Attorney General to study the issue, directing parts of the federal executive branch to do something, not trying to affect what the general citizenry may or may not do, because for the most part that would require legislative action.
I think you're exactly right. And one of the things that I was looking at, one of these, in fact, it's number 17, that talks about the release of a letter to health care providers clarifying that no federal law prohibits them from reporting threats of violence to law enforcement authorities. Interesting to me because, we've talked about similar backgrounds with law enforcement and that kind of thing. I'm very interested in that because basically what we're looking at there, I think, is a HIPAA issue that would prevent healthcare workers in many cases from releasing that information. So he's basically here saying there's not a federal regulation that prohibits it, but still we have to deal with the existing laws in place that would prohibit it. Is that correct?
You've honed in on, I think, one of the most interesting of the 23 executive orders, and it's not one that most people are likely to get all that exercised about, the idea that a doctor could report homicidal threats made by a patient.
Absolutely.
But to the extent that what the president is saying is, well, I'm going to clarify a gray area of HIPAA, or I'm going to remind doctors that there's no prohibition in HIPAA against reporting this kind of threats, that's fine. I mean, the president can send letters to anybody he wants to, just like anybody else can send a letter to anybody that they want to. If what the president is saying, though, is, well, I'm actually going to sort of amend HIPAA or change the law by executive order, well, he couldn't do that. So if there's something in HIPAA that protects those doctor-patient communications currently, an executive order would not be sufficient to change that. If the law already permits those communications to be disclosed, then an executive order reminding doctors of that fact obviously is perfectly fine.
So he's with an easy realm of doing that, but what folks need to understand, especially some of my friends in law enforcement, that's not going to just open a door and flood them with additional information that they can use, which would be great at the same time, but it's not going to do that because the law would have to be changed to change the HIPAA law that ensures privacy of patient information and patient-related information, whether it's psychological information or whether it's medical information.
Well, that's right. And if you look at another one of the executive orders, for example, the president proposes to have a national campaign about gun safety, emphasizing the importance of gun locks and that kind of stuff. Great, no problem there. If the president were trying to change the law to impose new legal requirements about gun storage or impose a nationwide gun lock requirement, that would require legislative action. So yes, most of these executive actions don't involve a change in law, won't regulate people any differently, but announce executive initiatives or campaigns or reminders, things of that nature, which are perfectly within the power of the president to do.
So the takeaway from all of these 23 executive orders, they are not and cannot be intrusive on a person's right to not only have whatever kind of assault rifle they want, but the ammunition or anything else. That has to be done through legislative act, either federally or on the state level, and the federal level is more predominant and covers anything the state does, unless we talked about the reverse situation a while ago. So I think that's important for folks to know. Is they look at this, there's this fear, well, you know, the President of the United States is going to do this, or I've even had people to say, well, the President said he was going to take our gun. He can't do that. There's just limitations.
That's right. And he could not do that, and nor has he tried to do that with this list of proposed executive actions. I think one way this issue sometimes comes up is people want to know if their local sheriff is going to help enforce these executive orders. And number one, local sheriffs can't be required to do that. By law, the federal government needs to enforce its own initiatives. But number two, there's nothing in this list that needs to be enforced. They're directions to federal executive agencies to do something or not do something. They're not legal requirements or prohibitions that a sheriff would ever be called upon to act on under any circumstances.
Absolutely. I'm glad you clarified that and pointed that out, and hopefully that'll rest people's mind at least that none of these are going to be imposed or impacting them in a negative way as far as their ownership of guns. Jeff, I want to take a moment. We're coming down to kind of the close of our show. Again, I want to thank you for being here, for taking your time to come down to southeastern North Carolina and speak to the folks here. I want to give you a minute or so just to wrap up of any particular thing that we've missed that you think folks need to know about.
Well, I don't think we've missed it. I think you've touched on this previously, but I think a really important thing in my mind is to turn down the volume a little bit on this debate. It's a polarizing issue. America's polarized about it for lots of reasons. The mainstream media probably contributes to that by selecting people who are at the extremes of this issue to talk about it. There's a lot of fear-mongering on both sides, and I think it would be really helpful for everybody to step back, take a breath, look at what's really being done, really being proposed, what the Constitution permits and prohibits, and have a sort of fact-based, a little bit more dispassionate look at this issue without the fear-mongering that's prevalent so far. So to me, that's the main takeaway from this discussion is, this is a serious issue with serious points on both sides. The extremes are neither legally nor practically desirable, and let's try to come together and find some common ground that can serve the interests of the country.
And I think you would agree that if folks do have an interest and concern in this, that they utilize the current structure we have, our political structure, to contact their representatives, whether it's in Washington or whether it's in Raleigh, North Carolina. If you live in North Carolina, contact your legislatures and express that to them, because they are the folks that are going to be making the laws and the statutes that deal directly with any controls or anything dealing with guns and the ownership of guns. Would you concur?
I would, and I think unfortunately we're in a situation where many of the existing issue advocacy groups on this topic are really at the extremes. It's hard to find an existing organization that's somewhere in the middle, so for folks who are somewhere in the middle, going directly to their representatives is the way to go. Again,
thank Jeff for being here, Jeff Welty with University of North Carolina School of Law, and thank you for being with us. We'll see you next week again on the radio.
Thank you for tuning in to this week's episode of We Should Know with host J.W. Simmons. If you have a question or comment regarding this or any episode, please send your email questions and or comments to jwsimmonsedu@gmail.com. And remember to tune in every Tuesday afternoon beginning at 2:30 for another informative episode of We Should Know.